How do you feel it went today?
I think it went really well. I don't think that our side could have argued the argument any better than they did. That the statute is really very clear. The other side would like to talk policy, and I think the closing statements about how industry shouldn't be able to just bulldoze over the rights of communities to decide how they should live shows a bit of their hand, and they're obviously, as you could see even from the case before this one that was argued, the judges asked questions on both sides. Even if, however they're going to decide the case, they ask questions, probing questions of both sides. But I think that at the end of the day, the law was and remains firmly on our side.
Help me understand the comment about the legislative remedies. In other words, I guess if the result of this, they say that local towns do not have the right, are preempted, don't have the right to zone out fracking or heavy industry or whatever, what would be the legislative remedy?
So the legislature, obviously the issue here is that the legislature was not crystal clear on whether or not zoning was preempted and confused. I think if they hadn't said anything, if it had ended with you can't regulate the industry, there'd be no question. If the exceptions had included zoning, there wouldn't be a question. But instead, because this was a revenue bill, because the concern was about finances, the two exceptions relate to finances, to taxation, which is not a typical power of a town, has to be expressly granted to a town, and this is a tax on production, not the land, and road use, which goes to operations. But that does confuse things a bit. So the legislature could clearly and constitutionally, if the case was decided against the town's rights, the legislature could absolutely go ahead and pass a law that said the towns could zone out fracking and oil and gas drilling. On the contrary, to the extent that the court decides that localities have the right to prohibit fracking, and the legislature went ahead and did what Pennsylvania did and said, no, there are no restrictions on fracking. You can frack anywhere and everywhere you want without regard to anything. In Pennsylvania, they found that to be unconstitutional. And I can't imagine that New York would be more, would be lower on the totem pole than Pennsylvania, where you can get away with anything. So that here, that would be an unconstitutional giveaway to just say that they could frack anywhere and everywhere. If there were siting commissions and they did it the way that they do when they do take away zoning, and they do it very clearly and they provide for local input and the like, that would be constitutional. But to just say localities have no say, I believe would fall under the same analysis that they had in Pennsylvania, that would be unconstitutional and just totally disrespectful of people's fundamental rights to decide where they want to live and how they want to live.
Helen, at the very end, the Chief Justice kind of outlined what this case is going to turn on. Could you kind of summarize what he said? He was talking about something about legislative intent and interpreting the law.
Right. So both sides have made, and especially the landowners and industry in this case, have made all sorts of policy arguments. This is about energy policy, this is about energy independence. We've never had an energy crisis, or we've never had a sand and gravel crisis, we've only had energy crises, and that because of those sort of policies, that it would not make sense to allow towns to ban this. And our side looks more to just the language of the statute, and if you read it, it is not clearly preempting zoning, and zoning has been treated differently. So what the judge was talking about is, I'm not going to consider these policy type arguments. Policy is the legislature's decision. The judicial branch, separation of powers 101, the judicial branch only interprets to try to figure out what the legislature did. It doesn't make policy judgments. It doesn't second guess the legislature and say, well, you made the law that says X, but you should have made the law say B, and so we're going to make it say B. So he was saying we're going to look at this language and we're going to parse what this language means, and like a very technical analysis. And when you do that, when you read the language, there are very basic statutory constructs, and one basic statutory construct is this, that an exclusion does not make the prohibition bigger. So if you say you can't do X, and then you carve out a piece of X and say, but you can do, A and B over here, that doesn't make X, the thing that you can't do, bigger. That doesn't somehow make that bigger. All it does is make it smaller. And their argument is that these exceptions make the prohibition against, somehow that makes the prohibition expand to include zoning, even though it doesn't on its face. And that's just not a correct statute. It violates one of the statutes, canons of statutory interpretation.
And what's the number now of the total number of towns that have passed bans?
Bans are approaching 80, and towns that have taken some form of action or another are between 180 and 200.
So you're talking close to 300 or 270?
No, 200 total.
200 total. So
200 total.
the
120 that have done moratoriums or other kinds of laws, and 70 to 80 that have passed actual permanent prohibitions.
And how would you characterize the DEC for staying silent on this case?
Well, I mean, clearly the DEC is, it's not exactly supposed to be making policy, but in today's world, the executive branch and the administrative agencies is more of a policy-making agency. So they're trying to figure out, in addition to the science, the politics. And I think the delay on this would appear to be entirely political. It's a hot potato. You're going to aggravate 50% of the people one way or the other. Cuomo would severely alienate a huge portion of his base if he were to allow this to happen before the election. So best for him to wait until after the election to make any action, because then he's at least reelected and doesn't have people, they're already making his life miserable following him around.
But it does seem to be the opinion of some of the justices that the law is vague and ambiguous, and that if the legislature had the intent to not allow towns to go forward with a ban, they certainly had the opportunity to say that in the legislation. So we saw a year ago, maybe 2 years ago, that Senator Seward withdrew a bill that would have really clarified this.
Right, and that would have, because again, that's a political issue, and nobody wants to make it's like you're a junior level executive at IBM. Any decision is a bad decision, and you're best off not making, if you don't make any decision, there's nothing for you to get in trouble for. So the arguments here that the legislature could fix it, they haven't, but that doesn't change how you interpret this statute, and you don't. It's another fundamental canon of statutory interpretation that you don't imply preemption of a constitutionally guaranteed power such as zoning. That's a right in the Constitution. It's a right it's a law, but it's also a constitutional.
Although it's
thing.
done in some sense.
So it's embedded also in the Constitution, and so you don't impliedly or simply by silence conclude that zoning has been preempted.
Right. They'd have to spell it out, such as with the cell towers, and they put it in those laws.
Right, and cell towers relate to, there's a federal interest there, it's a different law, and even there, the community doesn't have to allow it anywhere and everywhere. They just have to allow it somewhere.
Right.
And they can't, and the company has to show a need. And here, the industry is saying, we don't have to make any showing.
Right.
We can put this anywhere and everywhere without any regard to, there will be no consideration of local wishes or desires. And even with cell phone towers, you can request that they look at other sites, you can make decisions that they have to co-locate on poles, that they have to make the poles look a certain way, and at the end of the day, a cell phone tower doesn't fundamentally change the character of your town. You might not want to look at it, but it's not.
Like that being Ridge Frankenpine?
So,
Thank you.
all right,
Helen, didn't the DC, wasn't there some sort of official position from the DEC somewhere in this SGICE process about that they're not going to get involved in the zoning
This isn't
issue?
finalized, so it's impossible to know what the DEC's position is. They have made comments in drafts of this document that maybe there's going to be some requirement that the drillers have to check off a box that this is consistent with local zoning, but we've looked at permit files and they're half empty, blank, they don't answer questions, so there's the fact that there may or may not be a box on a permit application doesn't give me any comfort.
Thank you.